Imagine spending like 3 years of your life fighting this massive lawsuit.
Right. Just a grueling process.
Exactly. You pay hundreds of thousands of dollars in legal fees. You sit through months of discovery, a really tense jury trial, and you finally win. You are ecstatic.
Naturally.
But then the defendant appeals. And while you are sitting in the appellate court, the judge looks at the original paperwork, stops everything, and just throws your entire victory in the trash.
Oh, yeah. It is a completely devastating scenario.
And it wasn't because the jury was wrong or the evidence was bad. It's because the original court never actually had the fundamental power to hear your case in the first place.
It happens way more often than people realize, honestly. Mostly because lawyers misunderstand the invisible boundaries of the court system.
And that is exactly what we are getting into today. Welcome to our deep dive. If you're listening to this, you're likely preparing for the multi-state bar examination, the MBE.
A very tough exam.
Extremely tough. And you are tackling this in English, which, might be your second language. We know civil procedure can feel like a totally foreign language, just a maze of arbitrary rules and Latin phrases.
Right, but it doesn't have to be.
Exactly. Our mission for this session is to completely demystify one of the most heavily tested topics on that exam, which is federal subject matter jurisdiction.
Yes.
We're going to break down these source materials using very simple, clear English. We will look at the exact traps the exam writers lay out for you and figure out why these rules exist at all.
Understanding the why is really the secret here. When you just, memorize rules, they just fall right out of your head.
Totally.
But when you understand the underlying logic, the architecture of it, they start being traps. They become predictable patterns.
So let's look at the big picture from our notes. We're talking about subject matter jurisdiction. Let's define that right away. It is simply the power or the competence of a federal court to hear a specific type of case.
Right. It's their authority.
Yeah. If the court lacks this power, they literally cannot listen to your lawsuit. Over the next hour, we are exploring the 4 main pathways, like golden tickets, that get you into a federal court. We'll unpack diversity jurisdiction, federal question jurisdiction, removal, and supplemental jurisdiction.
But to grasp those tickets, we really have to start with the foundational premise of the whole American legal system.
Okay, lay it on us.
Federal courts are courts of limited jurisdiction. This is huge for the exam.
Yeah.
State courts are courts of general jurisdiction. I mean, a state court can hear almost anything, a car crash, a divorce, a contract dispute.
Right.
But federal courts are highly restricted. They only have power to hear cases that the U.S. Constitution and Congress specifically allow them to hear.
Okay, so the default setting for a federal court is basically off.
Yes, exactly.
They have to presume they do not have jurisdiction until someone actually proves they do.
Right. The burden of proof is always on the party bringing the case. The judge is actively looking for a reason to say, I do not have the power to hear this.
Let's use a visual here for the listener. Think of a federal district court, like an incredibly exclusive VIP nightclub.
I like that.
There's a very strict bouncer standing at the door, and that bouncer is the federal judge. When you walk up to the velvet rope, the bouncer assumes you don't belong inside. You have to hand over a specific golden ticket.
And if you don't have it,
You stay out on the street, which means you go file in state court.
that visual works perfectly for the first big MBE rule we need to cover, which is waiver and objections. Because this is about the court's constitutional power, it cannot be waived,
Wait, meaning what?
meaning it cannot be agreed to by the parties.
Let me make sure I'm translating this right. Say the plaintiff and the defendant both really want to be in federal court. They think the judge is smarter or whatever.
Sure.
They write up a contract, sign it, walk up to our bouncer and say, we both agree to be here. We waive all the rules. Let us in. What happens?
The bouncer turns them away.
Really?
Yeah.
Just like that.
It's just like that. The agreement of the parties means absolutely nothing. You cannot just gift power to a federal court because it's convenient for you. Only Congress grants that power.
Wow.
And this is a huge trick on the exam. They will give you a fact pattern where the defendant explicitly signs a document consenting to subject matter jurisdiction. It is a trap. Consent does not create power.
That is a major difference from personal jurisdiction, right? I know we aren't doing personal jurisdiction today, but just to contrast, you can agree to let a court have power over your physical person,
Yes, you can.
but you cannot agree to let them have power over the subject matter itself.
Precisely. And because it's about fundamental power, the court can bring up the issue on its own at any time. The text uses a Latin phrase for this, sua sponte.
Sua sponte. Meaning what, in plain English?
It just means on its own motion or voluntarily.
So even if the lawyers never say a word about it, the judge can just wake up mid-trial, look at the file and say, wait, I don't have the power to hear this, and shut it down. Sua sponte.
Yes. They can do it during discovery, in the middle of the trial, or even at the very end on appeal. The appellate court can raise it sua sponte and dismiss the whole case.
Which brings us right back to my nightmare scenario from the intro. We go through a whole trial, spend a fortune, win, and the appeals court throws it out years later.
That is the harsh reality. Every order, every ruling is basically void if they lacked power. Now, there is one very narrow exception in our notes. Based on a Supreme Court case called Travelers Indemnity Company v. Bailey.
Oh, let's explore that. What happens if nobody catches the mistake until years after the case is totally closed?
Right, so if the trial ends, appeals end, a final judgment is entered, and years pass, can the loser suddenly realize a mistake and try to tear up the final judgment?
Yeah, can they?
Usually no. Once a case is completely finalized, you generally cannot launch what's called a collateral attack, which is filing a brand new lawsuit just to attack the old one.
Okay, that makes sense.
The court in Travelers basically said, there has to be finality. Unless the original court's lack of jurisdiction was some egregious abuse of authority, a finalized judgment will usually stand. But remember, that only protects cases that are completely over. During the active lawsuit, the threat is always there.
Okay. Before we walk up to the bouncer with our first ticket, let's do a quick recap. A mental checklist for the listener studying for the MBE.
Good idea.
Number 1, subject matter jurisdiction is about power. Number 2, federal courts have limited power, so you have to prove you belong.
Right?
Number 3, you cannot waive it, you cannot agree to it. And number 4, the court can raise it sua sponte on its own at any time.
That is the foundation. If you keep those in mind, the actual rules will make so much more sense.
Okay, let's unpack this. Let's look at the first major ticket, diversity jurisdiction. I think of this ticket as asking 2 questions. Who are you? And how much money are you fighting over?
Those are the exact right questions. Diversity jurisdiction is from Section 1332. It requires 2 things at the exact same time. First, complete diversity of citizenship. Second, an amount in controversy over $75,000. Let's do the who first. Complete diversity.
Our notes mention a case here. Strawbridge v. Curtis. What is the rule from that?
Strawbridge established that complete diversity means no plaintiff can be a citizen of the same state as any defendant.
Okay, let's step away from the nightclub for a second and use a sports field. I think it visualizes it perfectly.
Let's hear it.
Imagine a football field. On the left side, you have team plaintiff. On the right side, you have team defendant. The Strawbridge rule says if you look at the home states of the players, no one on the left side can be from the same state as anyone on the right side.
That is highly accurate. If even one single player on team plaintiff is from Texas and one player on team defendant is from Texas, the referee blows the whistle. Game over. Complete diversity is destroyed.
But what about within the same team? Can 2 plaintiffs on the left side both be from New York?
Yes, absolutely. You can have 5 plaintiffs from New York, perfectly fine, as long as there is no defendant from New York on the other side. The boundary line is strictly between plaintiffs and defendants.
And just for our ESL listeners, when we say state here, are we just talking about the 50 U.S. states?
Good question. It includes the 50 states, but also the District of Columbia, Puerto Rico, and U.S. territories. So Puerto Rico versus Puerto Rico destroys diversity, too.
Got it. Now, the MBE loves exceptions. Is there ever a time where a federal court accepts minimal diversity, meaning just one plaintiff is from a different state than just one defendant?
Yes. Our text outlines 3 heavily tested exceptions where minimal diversity is enough. The first is the Federal Interpleader Act.
Let's define interpleader simply.
It's a tool. Say you hold some property or money and multiple people claim they own it. To avoid being sued by everyone, you just hand it to the court and say, you figure out who gets this.
Sounds practical.
It is. Under the Act, you only need minimal diversity among the people claiming the property. Just 2 claimants from different states is enough.
Exception number 2.
Massive class action lawsuits. Under the Class Action Fairness Act, if the money is over $5 million and there are at least 100 class members, the court only needs minimal diversity.
So if just one plaintiff in a giant class is from a different state than the defendant, they get in.
Exactly. Because Congress didn't want multi-million-dollar national lawsuits trapped in local state courts.
Makes sense. And the third exception is a very long name in the notes. The Multi-Party, Multi-Forum Trial Jurisdiction Act of 2002.
Yes, this law is for massive, terrible tragedies. It requires a single accident where at least 75 natural persons died at a specific location, like a commercial plane crash.
Wow, okay.
In those specific mass casualty events, minimal diversity gets the lawsuits into federal court.
Why did Congress do that?
Efficiency. If a plane crashes with victims from 30 states, 30 different state court lawsuits would be a nightmare. The federal system consolidates them. But you have to watch out for the abstention rules here.
Abstention, meaning the federal court steps back?
Right. Even with minimal diversity, the federal court must abstain, refuse jurisdiction if the vast majority of plaintiffs and primary defendants are from the same state, and that state's laws will govern.
So if a commuter train crashes in Ohio, and almost everyone is from Ohio, the federal court says, this is an Ohio tragedy, let Ohio handle it.
Exactly. It respects state sovereignty.
Okay, so we know the rule is complete diversity, mostly. But how does the bouncer actually check your ID? How do we know what state someone is a citizen of?
This is a huge trap on the exam. We have to look at different rules for different types of people. Let's start with human beings. For an individual, citizenship is determined by domicile.
Domicile. That sounds like where you live, but it's stricter than just an address, right?
Much stricter. It is your true, permanent home. To establish a new domicile, two things must happen at the exact same moment. First, physical presence. You have to travel to the state. Second, intent to remain indefinitely. You must plan to make it your permanent home base.
Let me test this with a hypothetical. My domicile is in New York. I have an apartment there, but I go to law school in Massachusetts. I rent an apartment in Boston. I live there for 3 years, get a library card. Have I changed my domicile to Massachusetts?
Likely no, because you are there for a temporary Berkes school. Unless you form the active intent to stay in Boston indefinitely after graduating, your domicile stays in New York. You have presence, but lack intent.
What if I'm super wealthy? I buy a summer house in Florida. I spend 6 months in New York, 6 months in Florida. Can I have 2 domiciles?
No. A human being can only have one domicile at a time. The law presumes your old domicile stays with you until you totally uproot your life and show intent to make the new place your permanent home.
Here is a classic MBE trap. I live in California, I get drafted into the military, and the government forces me to move to a base in Texas for 4 years. Or I get sent to a federal prison in Kansas. Do I automatically become a citizen of Texas or Kansas?
The answer is no. A compulsory change of location, being forced to move, does not change your domicile. You are physically present, but you did not voluntarily form the intent to stay. So you keep your old California domicile.
So humans have one domicile. Presence plus intent. Forced moves don't count.
Now, what about businesses? Because they don't have human intentions. How about a standard corporation?
Pay close attention here. A corporation can have 2 citizenships at the exact same time. First, it's a citizen of every state where it is incorporated.
Which is usually just Delaware, right? Because of favorable business laws.
Usually, yes.
Yeah.
But second, it is also a citizen of the state where it has its principal place of business.
So if a company incorporates in Delaware but operates out of New York, it holds 2 citizenships. If a Delaware plaintiff sues them, complete diversity is ruined. If a New York plaintiff sues them, complete diversity is ruined.
Correct. And courts used to struggle with defining principal place of business. Is it the most factories, the most sales?
But the Supreme Court settled this in Hertz Corpy.
Right.
Yes. They established the nerve center test. It's a bright line rule. The principal place of business is the single location where high-level officers direct, control, and coordinate the corporation.
The nerve center. So on an exam, if a company has plants in Texas, sales in Florida, but the CEO and executives are in a skyscraper in Chicago.
It's Chicago. That's the nerve center. It's where the brain is.
Got it. Now, what about other businesses like a partnership or an LLC? This feels dangerous.
It is the most dangerous trap on the exam. For unincorporated associations, partnerships, limited partnerships, LLCs, you do not look at where they were formed or their nerve center. The rule comes from Carden v. Arcoma Associates.
What did Carden say?
It ruled that an unincorporated association takes on the citizenship of every single one of its members or partners.
Wait, hold on. If I have a national law firm structured as a partnership, and there are partners in all 50 states,
Your partnership is a citizen of all 50 states.
that makes it mathematically almost impossible to ever get into federal court for a diversity case, because a plaintiff from anywhere will match a partner somewhere. Why such a punishing rule?
Historically, corporations are legal persons created by the state. Partnerships were just seen as groups of humans working together. The court refused to treat them like corporations unless Congress passed a new law. So you count every single partner. even the silent ones.
Wow. Listener, read the facts carefully. Megacorp Inc. means nerve center. Smith & Associates, a limited partnership, means count every partner.
Exactly. One final note on the who part. What if you're representing someone, like a guardian suing for a minor or an executor for a deceased person?
Does my citizenship matter?
Your citizenship is completely irrelevant. You just step into their shoes. You look solely at the domicile of the minor or the deceased person.
All right, we know how to check ID. But when does the bouncer check it? People move, companies relocate.
The bouncer checks your ID at the precise moment the lawsuit is filed.
So, I'm from New York. I sue my neighbor in New York. We are not diverse. But 2 weeks later, he permanently moves to California. Can I transfer to federal court now?
No. The snapshot is taken on the day of filing. A move later doesn't magically create jurisdiction, and it works in reverse. If you are diverse on day one and the defendant moves to your state a month later, they can't kick the case out. Jurisdiction existed on day one.
What if I try to trick the system? I want to sue my New York neighbor in federal court. I assign my claim to my cousin in New Jersey, and he files it.
The courts hate manipulation. Section 1359 says if a party is improperly joined just to manufacture jurisdiction, the court ignores it, like in the Kramer v. Caribbean Mills case. If your cousin promises to give you 95% of the winnings, the court sees through it. It's a fake assignment.
But what if it's real? Like my house burns down, my insurance company pays me, and they take over the right to sue the neighbor.
That's subrogation. It's a real business transaction. They actually own the claim now, so the court looks at the insurance company's citizenship.
Our notes also mention realignment. What is that?
It's the court making sure the sports teams are arranged correctly. If you list your business partner as a defendant just to make the diversity look good, the judge will look past the paperwork. If you both actually want the same outcome against a third party, the judge physically moves your partner to your side of the field. If that destroys diversity, case dismissed.
Okay, we have exhaustively covered who are you. Let's talk about how much are you fighting over. The amount in controversy.
The statute says the amount must exceed $75,000 exclusive of interest and costs.
Let me stop you. Listener, listen carefully. What if I sue for exactly $75,000?
You fail. You get kicked out. Exceeds is literal. It must be $75,000 and one single penny. The exam writers will trick you with exactly $75K. Do not fall for it.
Okay, more than $75K. But who decides what it's worth before the trial even happens? I think my broken arm is worth $100,000. The defendant thinks it's worth 10.
The rule strongly favors the plaintiff. The court accepts your good faith assertion in the complaint. As long as you claim in good faith it's over $75K, you're good.
When would a court say, we don't believe you?
Only if it appears to a legal certainty that you cannot possibly recover that much. Like, if you sue for a $1,500 broken laptop, you ask for $100,000 in punitive damages, but state contract law explicitly forbids punitive damages. It is a legal certainty you can't reach $75K.
But what if there's no legal cap? I sue for $100 in good faith, go to trial, and the jury only gives me $40,000. Does the bouncer blow the whistle and throw the verdict out?
No, that's a great hypothetical. Jurisdiction is determined at filing. As long as the $100,000 was claimed in good faith initially, the court keeps jurisdiction even if the final verdict is $1.
That protects the system. Now, what if I have a bunch of small claims? Can I pile them together to get over the $75K hurdle? The legal term is aggregation.
Aggregation is highly tested. It changes based on who is involved. Scenario 1, one single plaintiff versus one single defendant.
Me against you.
Right. In this 1 versus 1 scenario, you can aggregate all your claims against that defendant, even if they have nothing to do with each other.
So you rear-end my car, $40K damage. Plus 3 years ago, you ruined my boat engine, $40K damage. Totally separate events. Can I add them to reach $80?
Yes. Well, 1 versus 1 allows it. $80 gets you the ticket.
Scenario 2. Multiple plaintiffs. My brother and I are in the car when you hit us. I have $40K in bills. He has $40. Can we add them together?
No. Multiple plaintiffs generally cannot combine separate claims. Your body is separate from his. You evaluate them separately. You both fail.
Is there any exception?
Only if plaintiffs share a single undivided interest. Like if you co-own a valuable painting and the defendant destroys it. But for normal injuries, no.
Scenario 3. One plaintiff, multiple defendants. 2 people throw rocks at me. I sue rock thrower A for $40, rock thrower B for $40K.
No aggregation. You evaluate each defendant separately. You fail against both, unless they are jointly liable for a single harm as a team. Then you look at the total value of the single harm.
Awesome. Let's do a quick, simple English recap for the diversity ticket. First, complete diversity. Strawbridge. No matches across the field.
Interpleader. $5 class actions. Mass accidents. Third, domicile. Presence plus intent for humans. Force moves don't count. Fourth, corporations get 2 citizenships, incorporation and nerve center. Partnerships get citizenship for every partner. Fifth, check diversity on the day of filing. Sixth, the money must strictly exceed $75,000. Exactly, $75K is a trick. And seventh, aggregation. Add claims freely, only if it's exactly one plaintiff versus one defendant.
A perfect checklist. But what if you don't have 75K or you live in the same state? Are you locked out?
Not if you have the second golden ticket, federal question jurisdiction. This is part 3 of our notes. If diversity asked, who are you? Federal question asks, what is the law you're fighting over?
Exactly. Section 1331. Cases that arise under the Constitution, laws, or treaties of the United States.
Let's hit the biggest difference first. Does the bouncer care about my money here?
Not at all. No amount in controversy required. You could sue for a civil rights violation and ask for $1. You get the ticket.
But do I have to go to federal court? What if I want to file my civil rights case in my local state court?
Usually you can. State and federal courts share concurrent jurisdiction. The plaintiff chooses. State judges can read the U.S. Constitution.
When does Congress say, no, only federal courts can touch this?
For a few things, they grant exclusive jurisdiction. The big ones for the exam are bankruptcy, patent and copyright cases, and some antitrust issues. You cannot take a patent case to state court.
Okay, so how do we prove a lawsuit arises under federal law? Obviously, if a federal law says you can sue your boss for unpaid overtime, and I use that law, I have the ticket.
That's the easy scenario. Pure federal question.
But the MBE will give us a murky state law claim with a federal issue buried inside. Our notes mention the Grable test.
Yes, the Grable test. If your state law claim necessarily raises a stated federal issue, and that issue is actually disputed, substantial to the federal system, and doesn't upset the state-federal balance, you might get in.
Let's make it concrete with the Merrill Dow case. I take a drug, it makes me sick. I sue for state law negligence. But in my complaint, I say they were negligent because their label violated FDA standards. Does mentioning the FDA give me the ticket?
No, it does not. Merrill Dow tells us that just using a federal standard as a piece of evidence in a state law claim isn't enough. The core is still state law negligence. If courts let that in, every slip and fall involving a federal safety rule would flood the federal courts.
The federal issue has to be the engine, not just a bumper sticker. Which brings us to a huge unbending rule, the Well-Pleaded Complaint Rule.
If you remember nothing else here, remember this. The federal question must appear on the face of the plaintiff's original well-pleaded complaint from the Motley case.
The Motley case is a great story. Mr. and Mrs. Motley were in a train crash in the 1800s. The railroad gave them free passes for life. Years later, Congress passed a federal law forbidding free passes to stop bribery, so the railroad stopped honoring the passes.
Right. So the Motleys sued. Their claim was basic breach of contract, state law.
But they knew the railroad would use the new federal law as a defense. So the Motleys wrote in their complaint, they are breaking the contract, and they'll say the federal law makes them do it, but we argue that federal law is unconstitutional. They put a massive constitutional question right in the original paperwork.
And the Supreme Court said absolutely not. You only look at the necessary elements of the core claim. You ignore anticipated defenses. The core was state law breach of contract. So no federal jurisdiction.
Back to the bouncer. The well-pleaded complaint rule means the plaintiff, and only the plaintiff, must be holding the ticket.
Yes. What if the plaintiff sues for a basic state property trespass? The defendant answers and says, my defense is based on the First Amendment. Do they get into federal court?
I mean, it's the Constitution. It feels like they should.
It feels like it, but it's a hard no. A defense is a shield, not the engine. The bouncer turns them away. Why? Efficiency. The judge needs to look at the first piece of paper on day one and instantly know if they have power. If it depended on what the defendant might argue 3 weeks later, the system would be paralyzed.
That makes perfect sense. Let's recap part 3 for the MBE. First, federal question means the claim arises under federal law. Second, money doesn't matter, $1 is fine. Third, apply Grable. Don't let state claims pretend to be federal just by mentioning an agency. Fourth, the well-pleaded complaint rule. The federal issue must be the core of the plaintiff's claim. Defenses based on federal law do absolutely nothing.
Perfect. So we know how a plaintiff uses a ticket. But what if the plaintiff has a valid ticket, but decides to file in state court, and the defendant really wants to be in federal court?
Part 4 of our outline. Removal jurisdiction. To the back door.
Section 1441. It acts like a special vacuum tube that sucks a lawsuit out of state court and drops it onto a federal judge's desk. But the parameters are rigid.
Who can push the button?
Only the defendant. It is a one-way street, and the keys belong solely to the defense. A plaintiff can never remove a case.
Wait, hypothetical. I sue you in state court for $5,000. You get mad and file a massive $100,000 federal civil rights counterclaim against me. I'm now defending a huge federal claim. Can I remove it?
Brilliant hypothetical, but no. The original plaintiff chose the state forum. They have to live with it. Removal belongs only to the original defendants.
But the back door still leads to the VIP club, right? Does the case still need a golden ticket?
Absolutely. Removal doesn't create power. The case must have originally been able to be brought in federal court. It needs diversity over 75K or a federal question.
Now we hit a really sneaky rule, the in-state defendant rule.
Heavily tested. If a defendant wants to remove and the only no-why basis is diversity, they cannot remove if they are sued in their own home state.
Let me walk through the example. Texas corporation sues 2 Illinois defendants. The Texas plaintiff files it in an Illinois state court. Ticket check. Texas versus Illinois, complete diversity, over 75K. The ticket is valid.
Correct.
But the Texas plaintiff chose state court? The Illinois defendants say we want the federal court. Can they pull it through the back door?
No. Blocked by the in-state defendant rule.
Why? The ticket is valid.
Because of why diversity exists. It was created to protect out-of-state parties from local bias. The Texas corporation, the outsider, chose to walk into the lion's den of the Illinois state court. The Illinois defendants are the local lions. They don't need protection from local bias in their own home state. Congress says, stay in your state court.
Beautiful logic. If you don't need protection, you don't get the key. But what if the Texas company sued them for a federal civil rights violation?
Changes everything. If it's a federal question ticket, the in-state defendant rule disappears. They can remove immediately. It only polices diversity cases.
Is there a ticking clock for removal?
Yes. Exactly 30 days after receiving the initial pleading showing it's removable.
What if there are 3 defendants? Do they all have to agree?
The rule of unanimity. All served defendants must join or consent. If one refuses, it stays in state court.
What if the plaintiff is sneaky? They file a non-diverse case. 6 months later, they dismiss the non-diverse defendant. Boom, complete diversity. Does the 30-day clock start then?
Yes, they get a fresh 30 days from that amended paper. But there is the 1-year rule.
Explain that.
For diversity cases, a case cannot be removed more than 1 year after it originally commenced in state court. Congress thinks it's inefficient to rip a case away from state court after a whole year.
Doesn't that encourage plaintiffs to be devious? I have a $100K case. I'll just write $74,000 on the complaint, wait 1 year and 1 day, then amend it to $100K. The 1-year rule blocks removal.
You think like a devious lawyer. Congress anticipated that. There's an exception. If the judge finds the plaintiff acted in bad faith to prevent removal, like deliberately hiding the true amount, the judge ignores the 1-year limit.
The bouncer catches the trick. Okay, when they remove, do they need a suitcase of evidence to prove it's over 75K?
No. From the Dart Cherokee case, they just need a short, plain statement with a plausible allegation that it exceeds 75K.
So the file lands on the federal judge's desk. The state court loses power. But what if the federal judge looks at it and says, wait, there's no diversity, no federal question. The defendant was wrong.
The judge issues an order of remand, meaning shoving it back through the tube to state court.
And based on Part 1 rules, when can they do this for lack of subject matter jurisdiction?
At any time. Lack of SMJ cannot be waived. Day 1, day 100, they must remand.
But what if the ticket is totally valid, but the defendant made a procedural mistake? They waited 32 days to remove instead of 30. Can the judge remand it sua sponte a year later?
This is a vital distinction for the exam. A procedural defect is just a rule violation, not a constitutional power issue. So the burden is on the plaintiffs. The plaintiff has exactly 30 days after removal to file a motion to remand based on the late filing.
And if the plaintiff forgets?
They permanently waive the defect. The mistake is forgiven. Case stays in federal court.
Let me summarize that. SMJ defect equals fundamental power never waived, remand anytime. Procedural defect equals rule violation waived if the plaintiff doesn't complain within 30 days.
Exactly. And one last note. If a defendant removes a case with zero logical reason, just playing games to rack up bills, the judge will remand and order the defendant to pay the plaintiff's attorney's fees. From Martin v. Franklin Capital Corp.
Nice deterrent. Let's recap Part 4. First, removal is a one-way street, state to federal. Second, only the defendant can do it. Third, the in-state defendant rule blocks local defendants in diversity cases. Fourth, 30 days to remove. Almost agree. Fifth, the 1-year limit for diversity unless there's bad faith. Sixth, remand. SMJ defects anytime. Procedural defects need plaintiff action within 30 days.
Excellent. We are entering the final, most complex area, Part 5, Supplemental Jurisdiction.
Yeah, because real lawsuits are messy. The main lawsuit is Plaintiff A versus Defendant B. But then B cross-claims C, and C drags in a third-party contractor. It's a massive web.
It's a jurisdictional nightmare. The main claim has a golden ticket. But what about all those attached extra claims? If Defendant B brings a state law cross-claim for $10,000, that extra claim has no diversity, no federal question. Do we chop the lawsuit in half and try the small claim in state court?
Sounds terrible. That's why we have Section 1367, Supplemental Jurisdiction. I think of this as the +1 guest pass, or a gravitational pull. If the main claim is a massive planet with a valid ticket, can its gravity pull the ticketless moons into federal court?
I love that analogy. Section 1367 gives the judge power to hear those extra claims, but only if they are caught in the same orbit. The Supreme Court established the test in United Mine Workers v. Gibbs.
The Gibbs test, what is it?
The extra claim must arise from a common nucleus of operative fact as the original claim.
Let's put that in plain English.
It just means the core story is the same. They come from the exact same real-world event, same accident, same witnesses, same evidence. It's only logical to try them together.
Let's test the gravity in a federal question scenario. I sue my corporate employer in federal court for firing me based on gender. That's Title VII, federal law.
Right.
I have the ticket. I'm in.
Securely inside.
I also want to sue for assault and battery under state law because during the firing, my manager threw a heavy stapler at my head. State law claim. No federal question, no diversity. Can the federal court pull in my stapler claim?
Apply Gibbs. Do they share a common nucleus of operative fact? Yes. Same event, the explosive termination meeting. Section 1367 grants supplemental jurisdiction. The state claim rides the coattails into federal court.
That is wonderfully straightforward, but the notes say this gets incredibly messy for diversity cases.
Yes. Section 1367B is famously the hardest concept for law students. We need to slow down here.
Taking a deep breath, what is the problem with diversity? Why can't we just use the Gibbs test?
Because diversity rests on the sacred rule of complete diversity. No matches across the field. Congress was terrified that devious plaintiffs would use the +1 guest pass loophole to sneak non-diverse people onto the field and ruin the rule.
How would a plaintiff do that?
Hypothetical time. You are a New York plaintiff, severe construction accident. The general contractor is from New Jersey. The subcontractor who dropped a brick on you is from your home state, New York. Can you sue them both originally in federal court?
Let's see. New York versus New Jersey, NAD New York. Complete diversity is destroyed, so no.
Right. So a devious lawyer would say, I'll just sue the New Jersey contractor first, NY versus NJ, complete diversity. Once I'm safely inside, I'll use Rule 20 to join the NY subcontractor. I'll tell the judge it's the same accident, common nucleus of operative fact, let him in as a +1 guest.
Oh, I see the loophole. If the judge allows that, I completely bypass the diversity rule. I got a NY versus NY fight into federal court by sneaking them in second.
Exactly. And that is what Section 1367B prevents. It acts as a massive roadblock. In cases based solely on diversity, the court does not have supplemental jurisdiction over claims made by plaintiffs against persons joined under certain rules, like Rule 14, 19, 20, or 24.
So the roadblock only hits the plaintiff?
Yes. It stops the plaintiff from dragging in a non-diverse party.
Let's walk through example 1 from the text. Impleader under Rule 14. Iowa plaintiff sues Nebraska defendant for a car accident. $100,000.
Pause. Iowa versus Nebraska, over $75K. Complete diversity, valid ticket.
Okay, they're inside. The Nebraska defendant says, my brakes failed. It's the fault of the mechanic who fixed my car. The defendant uses Rule 14 to pull the mechanic into the lawsuit, demanding he pay. The mechanic lives in Iowa.
Visualize in the field. Original Iowa plaintiff on the left, original Nebraska defendant on the right, plus this newly dragged in Iowa mechanic.
Now, the original Iowa plaintiff looks across and says, I want to sue that mechanic directly too. Same accident, common nucleus. The plaintiff tries to use supplemental jurisdiction.
Does it work?
Well, Iowa plaintiff shooting a claim at Iowa mechanic is Iowa versus Iowa, breaks complete diversity. Does the roadblock stop them?
Yes. Section 1367B forbids the plaintiff from doing this. Bouncer says, no, take that to state court.
Makes sense. Protect the boundary. But example 2 twists my brain. It involves cross-claims. Arkansas plaintiff sues Oklahoma defendant 1 and Oklahoma defendant 2 $100,000.
Check the ticket. Arkansas versus 2 Oklahomas. No matches across the line. Valid ticket.
They are inside. Now, Defendant 1 gets angry and cross-claims Defendant 2. You caused this, pay for my car damage. The cross-claim is for $10,000.
Well, yeah.
Defendant 1 suing Defendant 2 is Oklahoma versus Oklahoma, and it's only $10,000. Doesn't the roadblock kick this out?
No. The roadblock does not slam down. The cross-claim stays in via supplemental jurisdiction.
Why? Why is the plaintiff blocked in example 1, but these defendants are allowed to do this?
Look at WHO is making the claim. The 1367B fence only applies to plaintiffs. When Oklahoma Def 1 sues Oklahoma Def 2, they are fighting amongst themselves on the right side of the field. It doesn't break the main boundary line of Arkansas versus Oklahoma. Complete diversity is structurally intact.
Wow,
So-
okay. That is critical. The fence is built to keep the plaintiff from ruining complete diversity. But behind the fence, defendants can cross-claim each other, even if those little fights aren't diverse.
If you see that fence on the exam, you will nail the hardest questions. Keep your eye on the plaintiff.
Phenomenal breakdown. One last piece. Even if gravity is perfect and there are no roadblocks, does the federal judge HVE to let the +1 guest in?
No. Section 1367C, it is always discretionary. The judge can say no.
Why would they?
4 main reasons. 1, highly novel or complex state law issue.
Yeah.
The judge says, let the state Supreme Court handle this. 2, the state claim substantially predominates. The +1 guess is a giant monster taking over the
Your
case.
tail wagging the dog.
Right. 3, the judge dismisses all the original federal claims really early. Before trial, they'll just send the leftover state claims back. And 4, a catch-all for exceptional circumstances. It's docket management.
We survived Part 5. Final recap of supplemental jurisdiction. First, Gibbs test, common nucleus of operative fact, same timeline. Second, federal question cases. It works beautifully. Third, diversity cases. Watch for the 1367B roadblock. Plaintiffs cannot use it to shoot claims at non-diverse parties, but defendants can cross-claim each other. Fourth, it's always discretionary. The judge can just say no.
An airtight summary. You've got the complete roadmap.
We covered a ton today. The bouncer enforcing limited jurisdiction, the sports field of diversity, the nerve center for businesses, the strict well-pleaded complaint rule, the one-way vacuum tube of removal, and the gravity of supplemental jurisdiction. To wrap up, give us a broader perspective. Why is this machine so complicated?
Think about the architectural friction. Why all these tickets, bouncers, and roadblocks? It's fundamentally about federalism, the balance of power. Every time a federal court takes a case, it strips power from a sovereign state court. Congress designed these excruciating rules so the federal government doesn't just swallow up the local justice system. As you study, remember, these aren't just arbitrary puzzles. They are load-bearing beams holding up the balance of power between two sovereigns, the borders.
A powerful framework, and it leaves me with a final provocative thought for the listener. We just talked about geographic rules, physical presence, where a skyscraper sits, but we are rapidly moving into a borderless digital reality. Remote workforces everywhere, decentralized autonomous organizations on the blockchain. Are these 18th century geographic rules ready for a 21st century digital landscape? How will the federal bouncer check the idea of a company that physically exists nowhere but digitally exists everywhere? The Supreme Court will inevitably have to grapple with this. Until then, you know the rules we have now. Remember the sports field. Look out for the exactly $75,000 trick. Read the word partnership carefully. You have the tools. Keep studying, and we will see you on the next deep dive.